I'm a big believer in second chances, even for people who commit serious crimes. Who deserves a second chance? Who gets one? And who decides? I'm Jessica Henry, and I'll be your host of Just Justice. I'm a former public defender, a professor of justice studies, and an award winning author. And I'm excited for us to find new ways to put justice back into our criminal legal system. Hello and welcome to Just Justice. My name is Jessica Henry and I'll be your host. Today I have the pleasure of welcoming Susan Bandis to the show. Susan is a nationally and internationally renowned legal scholar and a pioneer in the emerging study of the role of emotion in law. She has been a distinguished faculty member of the DePaul College of Law for many years, where she has received numerous awards from both the law school and the university for her teaching, scholarship, and service. Her legal career began at the Illinois Office of the State Appellate Defender, and she later worked as a civil rights attorney at the Illinois ACLU. Her groundbreaking book on the role of emotion in law, The Passions of Law, was published nearly 25 years ago. More recently, she has served as a co-editor on the Handbook of Law and Emotion. Susan Bandis, welcome to the show.
Thank you so much for having me, Jessica. I'm happy to be here.
I am really excited to talk to you. People don't really appreciate the role of emotion in the law, but emotion, and in particular expressions of remorse, for instance, by a person who caused harm, is kind of an important part of any conversation on second chances. And if I can just set the stage here, in the criminal legal system, there's often an expectation that people who are convicted of serious crimes are expected to show emotion, or frankly, not to show emotion, depending on what's happening at any given moment in that courtroom. But whether remorse and how remorse is expressed is often as important as the actual feeling of remorse that a person might have. And so that's the background. That's what I really want to talk with you about. And before we even go into the question of remorse, I'd like to go back to your work on law and emotion from the macro level and ask you, how do you define emotion?
I want to emphasize that my goal here is not to come up with a single accepted definition of emotion. That just isn't going to happen. And neuroscientists, psychologists, anthropologists, historians haven't done that. The idea is that our understanding of what emotion is and how it fits in with decision making is ever evolving. Now, what I am trying to do is bring to light the fact that the legal system is constantly making assumptions about what emotion is, how it works, and what role it should or should not play in legal proceedings. The background assumption that the law keeps going back to is let's not use emotion at all. And so my first goal is to say, look, it's there. It's being used all the time. Assumptions about emotion absolutely pervade the criminal justice system and the legal system more broadly. We can say, if we are going to be keeping people off death row or putting them on death row based on whether they look remorseful, which we are doing, then why don't we try to learn something about remorse? Why don't we sort of get out of our little comfort zone of legal rules and legal decisions and see what other fields know about what remorse is, about what remorse does, about whether remorse can be recognized in a courtroom?
Let's talk about remorse, because remorse is something, when we think about second chances, when we think about sort of this question of who should get a second chance, you often hear people talking about acceptance of responsibility, or people who are willing to, who are really remorseful for what they did. So could you tell us what remorse is?
I can try to define remorse best I can. There's no consensus about what remorse is. The problem we are dealing with here is that judges and jurors and parole officers and the media and the public all think they know what remorse is, and that judges and jurors tend to be so confident that they know what it is that they're willing to make life and death decisions about it. And that jurors are almost never actually given a definition of remorse. Neither are judges. None of those decision makers are actually given guidance on what remorse is or why they should care about it. And by thinking about what remorse is, we can also try to think about why it seems to matter so much to legal decision makers. So I think that remorse is both backward looking and forward looking. And I also think that it's a process, very painful process. Of looking back on the wrongful act and reflecting on how it impacted the person that you're feeling remorseful about, gaining empathy into how another person might feel, how your actions impacted another person, showing that you're someone who doesn't just think about yourself. This is important. People want to know that the people they are judging and evaluating have that kind of human impulse and that kind of insightful capability, right? To know I can harm other people and I wish I hadn't, and it really pains me that I did. We might call that backward thing regret. I really regret that I hurt that person so badly. But remorse seems to have a forward-looking component as well. And that is, I want to atone for what I did. I want to be a better person. It could be, that's not who I usually am. That was a deviation from who I was. Or it could be, that's not who I want to be. Maybe I was like that, but I don't want to be that person anymore. I want to atone. I want to not only become a better person myself, but I also want to atone to the person I have wronged. So that's the forward-looking component. So when I describe it that way, it's a pretty long, involved, complex process and a painful process. So in one way, that explains why decision makers might care about it so much. That forward-looking part, I want to atone, I want to become a better person, sure sounds like a promise not to do another crime.
And I was going to ask you about that, right? Because I know there is a belief that links the presence of remorse to the idea of reoffending. And the belief is that if someone is remorseful, they are less likely to reoffend. Do you know what the literature says about that? What does the research tell us?
There is literally no evidence that a person who's committed a violent crime and who feels remorseful is less likely to offend in the future. We may find evidence later, but there is currently no study that links remorse with decreased recidivism.
Wow.
Except in a very narrow set of circumstances involving juveniles who have perhaps been involved in a DUI or something of that nature. But the kinds of crimes that we're mainly talking about today, felonies, violent crimes, no evidence whatsoever. We care about remorse for two reasons. So the one is the one that I just mentioned. Judge Posner has a famous quote about this. Judge Posner, of course, was a law and economics scholar, not exactly someone we think of as a misty sentimentalist, but he believed that he said in a widely quoted opinion that people who are remorseful are well on the way to the kind of insight that will keep them from committing another crime. And it sounds intuitively obvious. And it's those intuitively obvious things that are the most dangerous about emotion, because judges believe it, jurors believe it. There's no evidence to support it.
So when you say it's dangerous, why is it dangerous if it's so intuitive?
Because not all our intuitions have any kind of a scientific grounding. So the starkest example of why it's dangerous is what occurs in a capital case. In a capital case in the United States, the jury is actually passing judgment not only on whether the defendant is guilty, but on whether the defendant should be executed or not. In non-capital cases, judges decide sentencing, but in capital cases, juries do. The Capital Jury Project interviewed hundreds and hundreds of jurors who had decided capital cases to find out what their thinking process looked like, and found that whether the defendant was remorseful was one of the top three reasons, and very often the top reason that they decided to sentence them to death. In most of those cases, almost all of them, they decided that the defendant was remorseless, did not show remorse. Now, let me add the kicker. In those cases, in most capital cases, defendants do not testify. Let's picture what happens here. The jury is sitting watching the defendant. The defendant is sitting silently at the table, the witness table, watching the evidence unfold. And in a capital case, the evidence is often extremely upsetting and horrific. The defendant is watching it, is not saying a word. The jury is watching the face and the body language of the defendant. The jury goes into the jury room to deliberate. Nobody instructs them in almost any case about remorse. It isn't even mentioned to them. They go into the jury room, and often the very first thing they talk about, and usually the thing they talk about most or quite frequently, did the defendant look remorseful while he was watching silently as the evidence unfolded? If not, we're going to send him to death. And that is why I say it's dangerous.
Also, I mean, what's interesting too about the example you gave is, I was a former public defender, and you often tell your client to say nothing, to not react, to sit stoically while the evidence is being portrayed by the prosecutor in a certain way or while witnesses are on the stand. And so the very fact that they're taking their lawyer's advice to sit quietly and not express emotion is then used against them. It's sort of a horrific idea. And yet, to your point, it's not sort of part of the formal legal process, yet we know it happens. And we know it happens with jurors. But then the question, of course, is in non-capital cases, what happens with judges?
Right. And just before I get to that question, to your point, there actually is no way to know that you're looking remorseful. You can imagine a lot of these jurors who were interviewed in the Capital Jury Project were sure they would know remorse if they saw it, but they almost never did. And when you think about it, it's kind of a setup. Here's somebody who everyone knows is fighting for his life in a death penalty case. It's, of course, to his advantage to show remorse if he can. As you say, often he's just being told or she's just being told to look demure and expressionless, which is not going to work. But if there was something that would work, we would know about it. If a defendant started crying when looking at the evidence, jurors are prone to say, oh, of course he's crying. His lawyer coached him to cry. So it's not like there's any particular way to look remorseful, even if you want to. It's kind of a damned if you do, damned if you don't situation.
You said we care about remorse for two reasons. So the second reason, tell me about
why jurors care and judges care about remorse. And this is where it gets really complicated. The question of whether remorse is tied to recidivism is an empirical question. We don't have any evidence that that's true. The harder point is jurors are looking for the humanity in a person.
Not just jurors, judges as well.
Absolutely right. They both are. They're looking for the humanity in a person. And unless they're instructed otherwise, well, unless jurors are instructed otherwise, and unless judges are trained otherwise, they're going to revert to the folk wisdom, to what we all think, that you can look at it at someone's face and figure it out. Even though judges are in a better position than jurors because they can have a colloquy with the defendant. They often have the defendant's words. Even if the defendant doesn't testify, they can talk to them at the sentencing hearing. It turns out judges believe the same thing jurors do, which is that facial expression and body language is an unfiltered window into the soul. And in one study in Connecticut, 23 judges, there were many of them, most of them said they could tell just by looking. When asked, what do you look for? One notable finding was half the judges said, well, if the defendant looks me straight in the eye, I know he's remorseful. And the other half said, if the defendant looks me straight in the eye, I think he's arrogant. And if he looks down at the floor, I know he's remorseful. That was just one of many examples. They're all over the place about what remorse looks like. And yet most of them were confident that they knew what it looked like.
Judges have this confidence, particularly, as you said, in a sentencing proceeding, that they can just look at a defendant and evaluate their remorse. But you've also talked about a lot of the biases that come into play. And so I'm wondering if you could talk a little bit about the role of cross-racial understanding of remorse or cross-cultural understanding of remorse, or even how judges evaluate juveniles' expression of remorse.
So let's talk about race for a minute, because there are a couple of really good studies on that. There was one study that I particularly liked because it, without getting into the weeds here, it looked at the federal sentencing guidelines. Most criminal cases are state cases, maybe 5% are in federal court, and those have uniform guidelines about sentencing. And those guidelines mention remorse. And it's one of the few statutes that does mention remorse. You can get a lower sentence for accepting responsibility, and accepting responsibility might be shown by your remorse. So the thought was, this is a federal guideline. It guides all federal judges. So we shouldn't see any racial differences here. And it was quite shocking what the researchers found. They found that in determining remorse, judges gave white defendants a break twice as often, fully twice as often as Black defendants. And researchers didn't know why. They could only speculate. They didn't interview the judges, but their speculation was that there was a mismatch between what the judges thought remorse should look like and what the defendants thought it looked like, A. And B, when we're looking at and trying to decode the emotions of people that are different from us, we are just less invested in doing it correctly.
Right. And I think, just to be clear, the federal bench, federal judiciary tends to be largely white. And so things have certainly expanded a little bit with new appointments. But one of the things that was underlying that study is that you had largely white judges making determinations about remorse against defendants who were of color.
Exactly. And even state judges, we're talking about a big class difference overall, and often a racial difference. People have trouble reading remorse across different lines. It could be ethnic lines, it could be racial lines, but Blackness is a double whammy because of the well-documented association that the media pushes between Blackness and dangerousness. And it's really between Blackness, dangerousness, incorrigibility, and that leads us right to lack of remorse. So, in kind of layman's terms, it could be like, well, if someone I know and care about does something wrong, I'll say, oh, he's such a good person, he had a bad day. But if someone different from me, and especially someone who I've been taught is from a entire race that's been relentlessly associated with dangerousness, does something wrong, then we are way too prone to say that's what people like that do.
Right. And this whole notion of future dangerousness, again, it has been debunked. It has been criticized in the legal doctrine. And yet it is something that floats out there and can have a tremendously negative impact on defendants of color. How does that analysis also come into play when you're talking about juveniles?
There are a couple of things that are going on with juveniles. One is that often, they have had to, or they have developed a very hard shell, an outward shell of toughness, and don't feel, like they want to be vulnerable and show emotions. Another is that it might take them a little time to really understand the gravity of the crime that they've committed. A third thing, and now I'm thinking very much about the Central Park Five, who are now called the Exonerated Five. They had a triple set of barriers. They were Black, they were juveniles, and they were innocent. And the judge assumed that because they weren't remorseful and because they were really quite upset and angry at being convicted of a horrific crime they didn't commit, that they were arrogant and that they were defiant. And they spent close to 15 years in prison before they were completely exonerated for the crime. And it's not only that they didn't show appropriate remorse at their sentencing hearings, it's that they didn't show it during the parole hearings either. And every time they said, I didn't do it, the parole officers would say, well, you really haven't accepted responsibility for your crimes.
I want to go back to a term you used. You referenced remorse as a performance. I don't know if you said performative or performance. I think that's also really interesting because when you've gone to trial and now you're being sentenced and maybe you do express your remorse, there's often skepticism, right? There's often this feeling that you're performing in order to get a benefit. And I'm wondering what you think. Isn't it hard to sort of read whether someone's actually expressing genuine remorse and whether they're just putting on a show?
It is impossible to know whether someone is genuinely remorseful in a courtroom. Maybe we can see if we could tell that if our spouse, who we've been married to for many years, is genuinely remorseful, or our child. But in the brief time slice of a sentencing courtroom, no, it's just not possible. We actually need to give up on the idea that genuine remorse can be read in the courtroom. When I use the word performance, I don't mean it to be critical or derogatory of defendants. What I'm trying to say there is that the defendant is forced to perform, even if the defendant decides not to testify. Carla Faye Tucker, who was put to death for a horrific double murder that I think it appears she eventually became extremely remorseful about during her years in death row. But at her sentencing hearing, her lawyer had told her to try to just look very professional and demure. So she did. And that night, the press wrote that she had looked cold and arrogant. The next day, she saw her father in the courtroom and waved to him. And that day, the press wrote that she was flirtatious and glib. And then after that, she just started looking down. But even looking down is an enforced performance. There is no way to opt out of the performance. The other double-edged part of this performance language is the jury and the judge do believe that the defendant is performing because they know that everything is riding, on what they think about the defendant, and that the defendant knows this himself. So it's very hard for a defendant, even if he is sincere, to convince a judge or jury that he's being sincere. There was a very moving case that a Canadian colleague shared with me from Toronto, where a man had killed, I think it was 4 people in a family while driving drunk. And he never said a word. He didn't defend himself at all during his trial. He was sentenced to 9 years in prison, which certainly in Canada is quite a hefty sentence. And after his sentence was imposed, he got up and addressed the victims in the courtroom and told them how sorry he was. And he said, "I'm telling you this now after I'm sentenced, because that's the only way I have to convince you that I'm genuine, that I'm sincere, that I'm not just doing it to get a lesser sentence." So for me, that kind of illustrates the bind that everybody is in the courtroom. The defendant is in that bind, but so are the judge and jury. This is a performance.
Right. I want to stay here for just one more minute. We're talking about trials and sentencing proceedings, right? So, 95% of cases in the American criminal legal system are resolved by guilty plea. So there is no trial. The defendant is not testifying. The defendant is not refusing to testify. We're not even talking about testimony. And at sentencing, it's often an agreed upon sentence, right, between the defendant and the prosecution, and the judge just signs off on it. Sometimes the defendant will plead guilty and let the judge make that determination. But even then, the judge is looking at a report that's generated by the Department of Probation that kind of, has done a deeper dive into the defendant's history and background and report about the offense itself. How do guilty pleas impact this conversation on remorse and sentencing?
Very strongly, because judges view a guilty plea as a sign of acceptance and responsibility and a sign of remorse. Now, sometimes judges want more than just a guilty plea if they are, care deeply about remorse. They want other language as well. But if a defendant doesn't plead guilty, basically the evidence shows that the judge will tax him. The judge's attitude is often, by making the court go to all the trouble of bringing you to trial, all the expense, all the inconvenience of proving your guilt, you have shown that you are not remorseful. Now, that is problematic, of course, because the whole foundation of our system is that it is the burden of the state to prove guilt beyond reasonable doubt, and that the defendant has a right to that trial. So this becomes a way of penalizing a defendant for asserting her right to trial.
And it is also interesting that judges are willing to think of guilty pleas as expressions of remorse when they're often just a practical, rational response to a very punitive legal system that says if you accept responsibility through the form of a guilty plea, you won't serve as many years in prison as you otherwise would.
And let me just say about that, that it gets back to the question of what is remorse. Look at the shape remorse is taking in that dynamic. It's basically the judge wanting the defendant to show respect for the court and by extension for the judge herself. I find that a little bit weird, honestly, that a defendant's decision to exercise her right to a fair trial gets turned into defiance and lack of respect when there's no reason to think it's meant that way.
Right, right. And the trial penalty is a real thing. So we've been talking a lot about the idea of sentencing, right? So whether it's a sentence on a guilty plea or a sentence after a trial or even a sentence after a death penalty case where you have a whole separate sentencing proceeding. But you also had said that remorse has a temporal component, right? That it's not something that just sort of occurs in one day. And in fact, I can imagine a person who has been charged with a very serious crime being so frightened and upset with themselves about the entire situation that they don't have time to engage in that reflective, emotional evaluation that you need to feel genuine remorse, right? So maybe remorse at sentencing is an expectation that's really unrealistic.
I agree with you. It's a brief time slice. A sentencing hearing might last a couple of days. It could last a few weeks. But when we think back to this description we talked about earlier about what kind of a process remorse is, it's almost a mistake to think of it as an emotion. If an emotion evokes for you something like fleeting joy or a flash of anger, remorse looks nothing like those things. It's basically a change of character or an effort to change character. That will take time. And so, no, the idea that that can be shown at trial, it seems to me to be very unrealistic. The idea that it can be shown at trial just by looking at someone's face is flat out absurd. But even if we have the words of the defendant, even if we have the sentencing report, which, let's be clear, the sentencing report is written by a human being who has all the same misconceptions about remorse that the rest of us do. No, it is too early.
It's too early, and yet we do look for it.
We insist on it at the sentencing hearing, and then in most cases, we lose interest in it entirely.
Right. And then, so, once someone has been convicted and once someone has been sentenced, particularly for serious crimes, they're often, especially in the United States, serving years and years and years and years and years in prison before perhaps they are eligible for parole. And the parole process is a very broken, very opaque system. We don't know a lot about it. It seems quite arbitrary depending on where you are or who you are. But one of the things that does seem to come up in many parole contexts is this seeking out by the parole board from the person who's serving all this time some kind of expression of acceptance of responsibility or remorse. And I'm wondering if acceptance of responsibility in that parole context is the same thing as remorse, and what you think about the idea of remorse as a factor for parole and parole release.
I mean, this is where I think the question gets really hard. I'm working on a book right now, actually.
What's it called? We'd love to take a look when it comes out.
Thank you. Well, it's this is the working title. I doubt this will be the title, but the working title is The Emotional Courtroom: How Hidden Passions Hijack Criminal Justice.
Ooh, I love that, the idea of emotions hijacking criminal justice.
Right. And so I'm looking at actually two particular high profile cases. One is Carla Faye Tucker, who was on death row in Texas for about 10 years. And the other is Judith Clark, who was in prison in New York State for the Brinks robbery that led to the death of 3 people. So in both those cases, we have accounts of what happened to these women during their years in prison. And, with the caveat that I would never claim that any of us can know for sure what is in the deepest heart of other people. There are lots of accounts in both cases, of genuine remorse over a course of years. With Judith Clark, it took her about 3 years to sort of move away from her certainty that her political beliefs excused or validated what she did or required what she did. It took her a number of years before, by the accounts of many people who worked with her, she became genuinely remorseful, really completely overwhelmed by the harm that she had contributed to and trying in every way she knew to make up for it. So, we have these accounts, and it does seem to suggest that, given time, people can come to some insight. I think the state of California actually uses that word insight to describe this ineffable quality we're looking for here, that they can come to empathy about the lives that they've harmed or even taken. And questions what to do about that.
Before we even answer that question, could you clarify something for me? Is remorse different from guilt? Because I can imagine feeling crushing guilt, and I'm wondering if that is the same thing as remorse.
We need to be very careful not to assume that there's some handy chart of what each of these emotions is. We need to remind ourselves that parole officers and everyone else who's passing judgment, in these situations doesn't have a handy little card saying, here's what remorse looks like. They can't tell, in most cases, remorse from guilt, from shame, from remorse about the crime, from remorse at getting caught, from all the other things. So when I say, here's how I think of the distinction, I am not saying that the legal system is using these specific criteria. I think remorse is different from guilt because remorse, as I was mentioning earlier, is not only backward looking, but forward looking. It's not only that I feel terrible about what I did, it's that I want to atone for it and become a better person. So that makes it a very complex emotion that really does seem tied in with this idea of insight, this idea of empathy, things that people genuinely do and should care about. So nobody's saying people shouldn't care about these things. The question is the legal system capable of discerning these things, capable enough that it can make decisions about imprisonment, freedom, life, and death based on them?
And so it sounds like you do think that remorse has a role to play in decisions like parole release, but that the question would be, or the concern would be, whether or not parole boards are up to the task of evaluating genuine expressions of remorse.
Right. So I think I would say I would have 3 takeaways about where remorse might be genuinely helpful. One is, and I know this is something that that you work on, that if we really do care about remorse beyond the brief time slice of this trial and sentencing hearing, and we should, if we believe that remorse makes somebody into a better person, a rehabilitated person, if we believe that rehabilitation is something that is a purpose of punishment, then we should care. Then we do need to start taking second looks. We do need to say a lot of people were put in prison for violent crimes when they were younger than 25 years old. They're in prison for many, many years. And in most cases, there is no parole. And, in a number of states, there is no parole. And so nobody looks back at them. We have lost all interest in their moral and emotional development. So if we really do believe that this is an important thing, then we shouldn't be using it just when it's too early at sentencing. We should be checking in with people, giving second looks all along the way. Secondly, I would agree completely that parole officers need to be trained in the same way that I believe that juries need to be instructed and judges need to be educated about all these problems that we've talked about with juveniles, with race, with cross ethnicity and cross class evaluation, with what remorse might look like, and with the fact that you cannot tell remorse from demeanor and body language. So parole officers need to be instructed on that. I think if remorse is something that should care about, then they need to be given some guidelines about what to do with it, because too often they will simply say, I don't really care what's happened to you over these years. The crime itself was so terrible that I don't even want to know about it. And if we take it seriously, then they should be told it has a certain weight. The last two things I would say are, if we care about remorse, then we need to get rid of life without parole and the death penalty, because both of those are assumptions that a person is irredeemable. And if we do think that people are capable of moral and emotional development, then we should make those changes as a very important signal that that's what we believe as a polity.
Yeah, and I mean, just to interject, I've been a long standing opponent of the death penalty. I'm very happy to say that on this podcast and anywhere else. And, particularly when we're talking about this notion of second chances and people perhaps being far more than the worst thing they've ever done, the death penalty just doesn't have a place in that discourse at all. So I couldn't agree with you more on that last point. So, Susan, the final thing I wanted to get back to you about, which we had mentioned earlier, was innocence, right? Because innocent people aren't remorseful because they didn't commit a crime. They might be upset or angry or scared, but they are not remorseful. They did nothing wrong. And so, how does this search for remorse coincide with or conflict with people who are trying to prove their innocence and clear their name and ideally get out of prison?
It's a terrible problem. Just to inject one more legal issue into this, if a defendant is not testifying, we all know that he has a Fifth Amendment right not to testify in his own trial. So let's just understand that this performance that we've been talking about, this sort of enforced performance of watching his face and watching his body language, becomes a kind of testimony, unless juries are instructed not to take it into account, which they aren't. And so an innocent person sitting and listening to horrific evidence, what is that person supposed to look like that is going to convince a jury or a judge that he is innocent? Now, let me distinguish two things here. There's the guilt phase and then there's the sentencing phase, right? So, oddly enough, the Scott Peterson case in California, Scott Peterson convicted of killing his wife, Lacey, and her unborn 8-month-old son, Connor, had this very expressionless look on his face throughout his trial. And really, from the beginning of the trial, while he still had the presumption of innocence, jurors began becoming convinced that he was guilty because he didn't look appropriately upset. So people have these scripts in their heads. But then at the sentencing hearing, someone's been convicted, and, getting back to the exonerated 5, former Central Park 5, they are upset and furious that they've been convicted of a crime they didn't commit. And that gets transmogrified into defiance and arrogance. So it's just extremely perilous situation.
Yeah, and at the parole board, an innocent person who doesn't accept responsibility is unlikely to get paroled, and yet, they didn't do anything. So accepting responsibility for a crime they didn't do can sort of eviscerate any potential innocence claim. It's a whole sticky wicket for sure. Susan, let me just ask you the final question that I ask everybody who comes on Just Justice. Do you think people deserve an opportunity to get a second chance? People who've committed terrible crimes, who are serving really long sentences? And what role, if any, do you think remorse should play in that evaluation?
Well, The first part half of your question is very easy. I certainly do. I think that, the United States uses much longer sentences than any other civilized country that I'm aware of. That we do know that most violent crimes occur when the perpetrators are 25 or younger than 25, and that people usually grow out of that impulse, and they gain impulse control and they change. And we say we care about their changing. And so I would say, if we say we care about people changing, if we're not just locking them up and throwing away the key, then yes, we do need to care about it. And we do need to care about it enough to revisit them occasionally. France does that. They revisit people that have been convicted of crimes that are in prison on fairly frequent intervals to check in on their moral development. And that is what we ought to be doing too. And so, the harder part of your question is, should remorse play a role in that? And yes, remorse does seem to be part of moral development. Insight, empathy, remorse, acceptance of responsibility. These are things we do want for people. I would just say that remorse is such a treacherous thing to try to evaluate. And we need to have a lot more humility, a lot more help from other sources like psychology and neuroscience and all the other people that are studying these things. The law should not think of itself as a little island that can't learn from other people. Other people know a lot more than we do about these emotions. So we need to become a lot more educated, and we need a lot more humility about our ability to see inside people's souls and to judge their characters.
Thank you so much, Susan Bandis, for coming on the show. It was such a pleasure to have you on Just Justice.
It's truly my pleasure. Thanks so much for having me.
Thanks so much for listening to this episode of Just Justice. If you like what you heard, please follow us wherever you listen to podcasts and tell a friend. To share an idea for the show or to stay in touch, head to jessicahenryjustice.com or find me on the socials at Jessica Henry Justice. See you next time.